Hi, everyone. This is BritSimon. So, Curtis Morrison and Rafael Urena are proposing a new lawsuit for DV-2022 selectees. And although Curtis has produced a video to explain all the terms of the lawsuit, I wanted to ask Curtis some questions about the lawsuit, and so I reached out to him today, and he very kindly agreed, even though it's fairly late at night in the West Coast here, he agreed to spend a few minutes with me and answer some questions. Now, some of you may not know, perhaps you don't know, but Curtis and I have battled in the past in various ways. We've disagreed many times. We agree on many things, but we also disagree on many things. And so, I'm very grateful that Curtis, sees it as valuable and interesting to continue a dialogue with me, and I appreciate that. And also to put himself on the spot, I thought was kind and brave of him to do that, because he probably knows I'm not going to pull any punches. I'm going to ask tough questions. I'm gonna give my opinion. And my opinion is not necessarily always flattering. So what you're about to see is probably about 40 minutes or so of an interview, a one-to-one conversation between myself and Curtis. It's not an advert. As I discuss in this interview, I have no financial interest in Curtis's lawsuits, any of his work or anything. Neither do I with any other lawyer. But I just wanted to ask some questions and try and clarify some of the points that you might want to consider if you're considering this lawsuit. So I'm going to play the interview now. It's going to be uncut. From the point I start is I'm going to go from there until the end, and you can judge for yourself what you think about the lawsuit. And whether I was challenging enough on Curtis. All right. So here we go. Enjoy. Hi, Curtis.
Hi. How are you?
I'm very good. I'm very good. Thanks for taking the time to do this. I really appreciate it, and I think it'll help help people understand what's going on. So actually, it's just struck me, I don't think we've ever spoken. I think this might be the first time we've ever spoken to each other, other than through email and stuff, right?
Right. Maybe we may have had a phone call. I don't know. So
yeah, I don't know. Maybe we have. Yeah. Okay. So we got your name there. That's good. Okay, so the reason that I reached out, and I appreciate, as I say, I appreciate you very much. Thanks for taking the time. Let me just stop that flashing thing. It's bothering me. The reason I reached out was because I think it was today you've published your plans for the 2020 lawsuit that yourself and Rafael plan to file on. I think you're filing December 20th. Is that right?
Yeah. You said 2020. You meant 2022.
Did I?
Yes.
2022 lawsuit.
Time flies, right?
Too late for the 2020. Yeah, you've taken care of that. But 2022 lawsuit for and you're filing on the 20th, as I understood it. I watched your video, and your deadline for people to sign up is by the 13th. Have I got all those dates right?
Yes.
Okay, cool. And it's really interesting because you're trying to address the tier 4 prioritization, right? And so you're laser focused on that particular aspect of the of the problems that we've got right now. So I just wanted to clarify a couple of things. So with the previous lawsuit, there was a similar sort of fee schedule, but there were some countries that didn't have to pay the $500 up front. Is it right? Am I right to say that's not going to be available for anyone? If people want to participate, they're going to need to pay the $500 up front?
That is correct. This particular lawsuit, this particular offering, this opportunity, we do not have deferred payments.
Right. Other than the the deferred part, the extra $1,000 once people enter the USA. That's
right.
I presume that's sort of
we don't have a deferred initial payments.
right.
I realize that a lot of people are disappointed about that, and I understand. It's my hope that future lawsuits will be able to have deferred payments, but for the one that we're doing now, to remove this barrier that's in the way for all DVs, but for all DV-2022s, we are not doing deferred initial payments on this one.
Yeah, it makes sense. I agree. It's a good strategy. People have been talking about this, and I think most people understand that the tiered prioritization is probably the biggest immediate threat to people being processed. In October, November, December, we've seen very, very few interviews being scheduled. That's partly because of the processing of KCC, but it's probably being driven by the tiered approach as well, the tier 4 approach, and so you're attacking that. So people joining this lawsuit need to understand that sort of laser focus aspect, because this is going to be quite different from what I understand you to have said than the previous lawsuits. There's a few differences. The fee schedule is one. The fact that you're not going to provide sort of personal assistance to help with consular scheduling is another, and the sort of limited but focused scope is probably the third that I can see in terms of the tier 4 prioritization. And as I understand it, if you can achieve the removal of the tier 4 prioritization, then you will have achieved your goal of the lawsuit, and so then you will have won, and people will be, we hope, then able to process. Have I understood all of those differences correctly, or is there anything else that's different about this one?
Let me think if there's anything else different about this one. We're going to do a different litigation strategy once the case is filed. Our firm, you follow us, so you know this. We usually file a motion for preliminary injunction with our group cases.
Right.
We're going to sort of use the approach that Mr. Cuck used with Go last year.
Okay.
And approach the government and say, hey, let's just set up a briefing schedule for summary judgment. Get this over with. If you feel like you're right on the law and we feel like we're right on the law, let's just hash it out and let the judge make a decision, and it's final.
Okay.
So we're going to go straight to that. And there's a couple reasons behind that, but the big thing is to win on a motion for preliminary injunction, you have to show the likelihood of like imminent harm. And that's very difficult to do when there's 10, 11 months left in the fiscal year. Yeah. So the lawsuit, the summary judgment route is the plan. That's
really interesting. I know you well enough through things you've said that you won't want to sort of reveal all of your strategy. I get that. I understand that. But I must admit, I had assumed during the course of today that you were going to go for a PI to try and stop the immediate harm of what Judge Mehta had previously pointed out was an unlawful behavior anyway. So it's really interesting. I understand your change of strategy, but I understand also the higher barrier to get a PI. So that makes sense. You've got to meet a higher standard from a proof point of view. I believe it's
actually interesting. You have to meet a higher standard in showing the injury is likelihood to occur. Yeah. But as far as like whether or not you're going to win on the merits, it's depending on which circuit you're in. It's like, are there substantial questions going to the merits? You don't actually have to win. It's actually a lower barrier for motions for preliminary injunction, which is why I'm kind of, I favor them usually. However, in this case, we're too far away from the end of the fiscal year for a motion for preliminary injunction to be the one not to go.
And that's because you can't necessarily show the immediate. People are not going to understand this, Curtis. So I wonder if you don't mind me trying to clarify. It's because of the length of time left, you can't show that the sort of near and present danger, the immediate harm being caused. We all know it's going to be harmful, but it's difficult to show that to the court that that time really is running out, and and it's going to be harmful. Have I understood that correctly?
Yes, and we've seen people, we've seen attorneys bring cases early.
Too early,
that's what happens. We saw that with
Jim Hacking.
Auto. We saw that with Wynn the year before in 2020. And so if you bring a case early, the PI or the TRO immediate relief, while it makes sense to us, it doesn't make sense to the court's procedures. So the route we're going, motion for summary judgment, makes sense for the court's procedures. Now, here's something interesting that I didn't talk about in the prospectus, really. We don't know if the judge will give us relief just for our named plaintiffs, or will give relief for all DV-2021 selectee 2022 selectees.
You're doing me. Yeah. No, I had thought about that too. It strikes me that if you obviously can't choose the judge, but if this went in front of Judge Mehta again, he took a very firm position in his opinion on September 9th on the tiered for prioritization, saying that there's no law to back it up, essentially saying it was unlawful. Correct. He seemed very convinced, and in that case, although he didn't have a class action before him at that point, he chose to make that ruling applicable to all DV-2021 cases. In other words, not just named plaintiffs. So to your point, it also occurred to me today that people joining the lawsuit again need to understand that if you win, and it's an if, and I want to cover some of these sort of caveats because people are getting concerned. But if you win, it could easily be a judgment for only named plaintiffs, or a judgment that actually removes it for all DV-2022 selectees. You have no way to control that, Curtis, right? Yeah.
Right. If you go to the tiered approach website for the State Department, it has a little asterisk there for the good luck to say, hey, this doesn't apply to DV 2021 because of good luck. So we don't know if we're going to get another asterisk, or we're going to get the asterisk says this doesn't apply to plaintiffs in this case. That's kind of up to the judge, and that's only if we win, right? Yeah,
but that little asterisk says it's because of the judgment in the good luck case. But it applies to everybody, right? I've not misunderstood that, right?
That was one of the things that's interesting about Judge Mehta's orders is he, on the September 30th order, he's like, oh, I don't have a class action, so I can't give relief for everyone.
Right.
But he had just done that on September 9th, and he had just done that in September 4th the previous year. So
exactly.
That confuses some people, and I think maybe he's not thought it out. I don't know. Maybe there's a distinction there between initial preliminary injunction relief and final preliminary injunction relief. I'm not sure. Right.
Okay. Okay. Couple more questions. I don't know how much time you've got, by the way. We didn't discuss that. But okay. We'll take a few minutes if you don't mind. But so I must admit, I've got a concern about the strategy, and let me sort of play out a sort of a scenario, and you can, perhaps just sort of understand what the concern is. I believe, particularly if this went in front of Judge Mehta, I believe that you have all the skills, all the arguments, all of the law is on your side to win. I think just when you announced this today, and in fact prior to this, I believe this should be, you've got a pretty good chance of success. I want to say people need to understand, nothing is guaranteed. And I think you said that in your frequently asked question about this case. And it's important for people to understand there's no guarantee of a win. But I personally think, as a layman, I'm just a layman, it seems like you have a good chance of success. You know, do you feel confident?
I feel confident, but I'll feel a lot more confident after we file the case and we're assigned to one of the
particularly with Judge Mehta, who understands it so well. Yeah, absolutely. You know, not all the judges have had the same sort of, you know, the same sort of reaction to some of the same arguments. But Judge Mehta has spent a lot of time getting to understand these things, and I think he understands things very well. So, so yeah, if we got lucky on that, and your case got in front of Judge Mehta, I think that would be tremendous news. But here's the thing: if you get either a judgment that removes Tier 4 Tier 4 prioritization for either all selectees in DV-2022 or your named plaintiffs, then for those named plaintiffs, they would have had a big barrier removed. No doubt about that. I totally agree with your strategy. There's no doubt. But there's no sort of, there's no telling what could happen in terms of KCC continuing to walk slow, right? Or embassies being closed, or embassies refusing to allow cases to move from one embassy to another. And your lawsuit can't help, or isn't planning to help, with those other things. Am I understanding that correctly?
I don't want to give false hope that it would guarantee a visa or anything like that.
Right.
But there's a possibility that the judge issues an order that asks for the adjudication of plaintiffs' visas. Right. If you'll remember, there was a lawsuit that we filed called Young that challenged 10014 in the Northern District of California. And it wasn't for DVs, it was for family-based. And the judge said, okay, this proclamation can't apply to these plaintiffs, and go ahead and adjudicate their visas. So that same scenario could play out here.
Sort of an order. It's an instruction from the judge. It's sort of an order. It's not an order in terms of.
It was an order with Young.
Oh, it was an actual order.
Yeah. And we've seen those other. Judge Kogan did it a few years ago with a case called Harvey. So judges can do that. They do have it within their power. That might be one of the downsides of getting to the Judge Mehta assignment, because based on his last few orders, I wouldn't expect him to do that.
Because he's split the baby a bit. He's not wanted to give
odds. He doesn't want you to use a lawsuit to improve your odds. Well, it's a little crazy to think like that, because why do people? So what? Everybody has no chance, and that's the way it's supposed to be.
Right. Yeah. Exactly. I was particularly frustrated. You'll have seen, and I provided you the numbers showing that you know, that we were way behind where we should have been. So he wasn't. His argument. I agree with you. His argument about improving people's odds. Really, I just didn't agree with that. I understood. You know, he was trying to sort of be careful with the way he was applying the law, and perhaps pretending or protecting being appealed. But to be honest with you, I don't think he had that part of it right. But who am I to say? You know, it's I'm just.
Well, I definitely don't. And the reason I don't think he got that part of it right is that I have 14,000 families that are not going to get visas. You know, we've got like 6,914 that will.
Yeah.
And good luck. And you've got 14,000 that won't. And all of them are, I'm saying families, plaintiffs. I'm sorry, all these plaintiffs, the 22,000 plaintiffs, and good luck, are in limbo.
Yeah.
While they wait. And that's
and they don't know who's going to, I mean, yeah, it sucks. They don't know who is going to get.
Yeah.
Yeah. No, I know it sucks. Yeah, but I have to say though, I get a lot of for some reason I'm getting a lot of criticism in the DV world personally right now for a couple of things. Number one, people assume that I'm working for you or for Charles Cook and Co. Or I'm advertising lawsuits, which is not true. Actually, let me just ask you: have I ever asked for, Curtis? Have you ever offered? Have I ever been paid in any way for anything I've done for you or for? To your knowledge,
I've never compensated you. I'm sorry.
No, and you never will. Frankly, I'm never going to ask you. I have a very good job. I do this as a part-time thing, as sort of a hobby rather than for any sort of income. So no, I mean, I'm always delighted to help you. You and I have had many conversations. Some of them have been arguments.
Yeah.
we've had a complicated relationship of butting heads sometimes.
Right.
But we've never had a commercial.
From them with a little bit more knowledge, though. I understand things better when I argue about them. So
yeah, but yeah, we've never had a commercial relationship. So I just wanted to clear that up. The other thing that people have been annoyed about is that I've been trying to explain to people that a lot of people have said, well, the lawsuits didn't work, and it's absolute bullshit. So in 2022, for example, at the point of the end of July. Sorry, in 2021, DV-2021. At the end of July, in a normal year, KCC stopped scheduling interviews. And at the end of July, in DV-2021, we have the data to show that about 12,000 people had been scheduled for interviews, were ready or above. They'd either been issued or they'd been refused or they were scheduled, etc. Everything that happened between from basically the 1st of August to the end of the year was because of the lawsuits, right? So the number went from about 12,000 to 20,000 and something, I believe. So there's about 8,000 or 9,000 people additional because of the lawsuits actually did get action in just that period of time.
I would say that the ones before July that you're talking about, those 15,000, that they wouldn't have been issued if it wasn't for lawsuits.
Many of them wouldn't, exactly.
Many of them, putting pressure on the administration to remove 10014. 10014 was removed.
Another win.
Because judges were about to remove it for him.
Exactly. So 10014, you're right, that was a win. The activity from July onwards, the activity before July, and we have proof of that now because of this May 20th processing thing, has given us the proof we needed to find out that effectively KCC moved their resources in late May from DV-2022 processing to DV-2021. They were doing that because they wanted to show Judge Mehta that they were working on the cases. So, this perspective that the lawsuits don't work or whatever is absolute bullshit, frankly. The same thing can be said for DV-2020 because from September 4th, 2020 to the end of the month, there are about 7,000 visas issued under the Gomez and related cases, Mohammed Fongjong, Aka, and so on, and Kennedy. And those would never have got issued. And then another order was that those visas that were issued in September, they all expired, or they mainly expired. So Judge Mehta stepped in again and said, okay, we'll give them another 6 months, even though those visas have expired. None of those things that I just talked about would have happened without the lawsuits. Never mind the reservation, never mind the 9,095 or the 6,900 or the RIDE 966 or the Go 465 or whatever it is. Right? All of those are, yes, it's annoying that we have to wait for them. And yes, it's annoying it didn't cover all the plaintiffs. But people have got to understand, we've seen probably 25,000 people, probably more than that, who got visas in 2020 and 2021 that would never have got that without lawsuits. So it drives me nuts, I have to say. People are so short-sighted and ignorant of the fact.
I think if they're looking at the numbers, I kind of understand where they're coming from because
they're frustrated. I get that too.
If other people got visas but you didn't get one, you still didn't get one. So
absolutely, exactly. If you look at it from a personal point of view, it's terrible. I'm an interested observer. I'm not actually involved, so I just look at the overall numbers and say, okay, look, 10,000 extra visas is better than no extra visas. 1,000 or one extra visa is better than none. So, to me, it's a win, but I understand it's an emotional disaster for someone if they've, if they've been waiting and they assume they were going to get a visa and then they don't, and other people do. Okay, so that brings me to another thought process I wanted to ask you about. I think you've been criticized in the past. This stuff is hard to do because either piss off these people or you piss off these people. There were a couple of things that went on. Number one, allowing some countries participate in the DV-2021 case without payment meant that there were a lot more people in that lawsuit, in the Good Luck lawsuit, right? And then, and some people felt that it was unfair. From some countries you would pay, and from other countries you wouldn't pay. So you're kind of addressing that in this lawsuit because you're saying everybody's going to pay. But of course, now we're going to have a bunch of pissed off people because they have to pay, and $500 is a lot of money in some countries, right? I don't think people understand. I tried to sort of argue the other day with someone that, look, you've got to look at this in USA terms, because $500 in America, you can earn that money back very quickly. It's a lot if you're living and working in Ethiopia or something. It's a fortune. $500 is a lot of money, but when they come here, they'll be able to earn that money back. And so, frankly, it's not that expensive if you look at American standards. The other thing I wanted to say to you and just sort of check with you, just before the end of the year, I was contacted by a couple of people who were offered by other lawyers, not yourself and not Charles Cook and Co. They were offered sort of individual lawsuits. And one of the lawsuits was being offered for the price of $15,000 per selectee, per case. Had you heard that? Were you aware of that?
Yes, there were maybe a dozen of those.
Right.
I filed 2 myself, and then I was the pro hoc vice attorney on behalf of a couple, and they got rolled into Good Luck. So
right.
Basically, the people that complained about Good Luck pricing, they should be grateful, because
that's what I was driving
people paid a lot more to be part of Good Luck.
Yeah, exactly. I mean, the lawyers, sorry, Curtis, but you guys, you're expensive, right? And you've had to invest in your education. You've probably paid several $100,000 in your education towards your license, etc. So I don't personally begrudge it. And I paid for my H1 visa, which I obtained through my brother's company. My family, because it was his money essentially, paid $10,000 for processing legal fees on my H1 visa before I got my green card, which was being processed at the same time. So I only actually used the H1 for 6 months. But it cost us $10,000. So I think people just don't understand how expensive it is to actually hire a lawyer if that lawyer is going to work for you. And the costs, people are complaining about $500 or $1,500, but frankly, it could be a lot more. So
if it was just me, we wouldn't have to charge this much. The problem is I can't do this alone, and
right.
I need staff. And so I think maybe the first time I talked to you, I did not really have a staff. I had in 2020, I had Amir and maybe Philip, and like there was like Rafael, there was like 5 of us max, maybe.
Exactly.
So
and you very quickly built up this enormous, frankly, organization and ability to onboard a huge amount of cases. 24,000 people in the Good Luck case is almost unheard of. But that took infrastructure. That took a large number of of people sort of supporting in the background, even though it was yourself and Abdir and Rafael who were the faces, as it were. But but there was obviously a lot of people in your team behind the scenes.
And and we're having to stay behind the scenes in that case the whole time too, because lots of life developments happen. People have children, get married, get divorced while they're waiting for the lawsuit, and we have to talk them through that those kind of situations. So our staff is extremely busy with helping support for people we have, and that's one of the biggest factors in why we are not offering paralegal support in this next opportunity. But here's the other one: you've got lots of time between now and September. So the paralegal support is not as vital. Let's just say you send the wrong email. If you're a DV and you send an email asking for the wrong thing or something, or a couple weeks later, you can fix it between now and September 30th.
Yeah, exactly.
Paralegals support, consular processing support is really important in September.
Yeah, absolutely. No, I agree. I agree. I mean, the methods of contacting the embassy, it's not so difficult, but it gets very difficult when there's a time crunch. So I absolutely agree. I understand why you've made that decision for this case. For the strategy that you're going for, what will be the timeline, do you think, of laying out that sort of plan to get towards the summary judgment? How long should people expect this case to take? Is there a way you can estimate that?
This is very frustrating. I can't, because I don't know how cooperative the government will be in stipulating to going straight to summary judgment. I think they were pretty cooperative with Mr. Cuck with the Go case, but then there was different things going on. There were other lawsuits. As to my awareness, this is the only DV-2022 lawsuit yet, so that shouldn't be a factor.
Agreed.
The biggest factor will be the fact that they're destined to lose this case if the judge follows precedent. Okay, there's something called it's Latin res judicata. If a legal issue has already been litigated, they don't litigate it again. That's it. And this is an identical legal issue. The legality of the tiered approach prioritization scheme as applied to DVs. We just litigated it. We already know how it answers. So there's a good argument that the government can't even argue against it because they just lost on this. Right? Well,
so they did, but they also appealed the September 9th thing, didn't they?
Yes, they did. So they filed their notice of appeal on that, and I checked with the circuit court today, and that process has not started yet. So, but there's no stay on the order because they filed the notice of appeal. It keeps going. The implementation of the order keeps going.
Yeah.
Of course.
So it's interesting. It's going to be. I mean, it's going to be interesting. People, again, I don't think will understand this. People always want black and white answers, and it's not possible to give those answers either in terms of timelines or outcomes or whatever. But if for example, if the September 9th judgment were successfully appealed, then your point about the precedent has already been set is weakened, right? If they were to successfully appeal that, if that was within the timeline.
It would be extremely weakened.
Yeah, exactly. So people need to understand
that decision before we get our decision.
Exactly, and you can't really predict the timelines that are going to be with your December 20th filing. Who knows what will happen by then?
District courts go a lot faster than circuit courts.
Okay.
The times when you can get into a circuit court of appeals and get an answer quick is like when someone's incarcerated, when someone's rights are like the president, something like that, Obamacare, you can go to the appeals, you can get an accelerated schedule for your appeal if the issue is going to cause somebody like a bad injury, and the government can't say, oh no, we're going to be so injured if people immigrate. They can't do that.
Right. So you're likely to get to file the lawsuit while the appeal is still pending. There's no stay. And so you will be able to refer to that as, well, we have precedent. We have legal precedent. We've had this argument. It's been ruled on, particularly if you're in front of Judge Mehta. He will understand the argument immediately. But the government, to your point, may or may not, roll over on this. Frankly, after getting their asses kicked in DV-2020 and DV-2021, I'd be amazed if they keep on arguing, but they just seem to arguing, don't they?
And yes, if it was me, I would just do away with the tiered approach.
Yeah.
And that's a possibility that they could do. I don't think it's likely because they just won an order against us on the tiered approach for family-based categories in New York. And they're appealing the good luck order, like you said. So I think that this is like a new toy for them. And they want to hold it as tight as they can. It's their favorite toy. It's how they can keep immigrants out and blame it on the COVID. And it's so funny to think that they could prioritize certain immigrants and say, we're doing this because of COVID. And it's like, do the immigrants in tier 2 have less COVID than tier 4? No.
That's ridiculous. No. I mean, ostensibly it's about that. It's also about the backlogs, but they cause the backlogs. You know, it's really frustrating.
Well, what's funny about that is now you'll see a tweet every once in a while where they say the tiered approach, the goal of it is to eliminate the backlogs.
To eliminate the backlog.
That doesn't make sense when you first think about it. If you let somebody skip in line, it doesn't eliminate the backlog. Yeah. But then if you realize what it actually does to tier 4 and tier 3, if DVs aren't issued visas, they're gone. They got rid of them. So they got rid of them. Okay. And then if family preference categories, they can roll over. So in a way, the injury could be the actual goal. They could be trying to eliminate the backlog by eliminating how many people get visas.
Yeah. it's very cool.
We voted for these guys, right?
Yeah. Bloody lawyers, Curtis, is what it is. It's bloody lawyers. You know, the lawyers are just, it seems like they just want to argue. Nobody's stopping them arguing. And so they're just enjoying the argument. So I don't know. It's crazy.
I don't know.
Okay. So I'm really a lot clearer on your strategy, which is great. I appreciate that. As I say, people will ask me. And so I want to be sort of honest. And actually a couple of times when I've created videos or blog articles, you've been kind enough to sort of give me your feedback as to whether I was fair or not. And, because I'm independent, I can say whatever the hell I like. You don't have to agree with me, obviously. But here's my sort of, thinking, and you tell me if I'm wrong. I suspect you'll probably get less people for this lawsuit than good luck by far, because it's going to be paid for and because the goal is different, right? It's to remove the tiered approach. And people might sit back and say, okay, I'll take a gamble because I've got more time on not signing up for this lawsuit, right? But for the people that sign up for the lawsuit, if they get the tiered prioritization removed, they won't be out of the woods yet. They're not guaranteed. Things will be easier for them, particularly if it's for named plaintiffs, but it could be easier for everyone else too if tier 4 is removed. And so, they will still, in my opinion, I think they're still going to need help. I could see a time, unless this is fixed soon, when we'll need another reservation of visas at the end of September. That bit worries me, I have to say, and I don't quite understand how you're going to rationalize someone who's paid for one lawsuit and then do they pay again, or do you move? I don't know how you're going to do that, Curtis, and I don't expect you to answer, but it worries me, I have to say. That bit of it worries me.
I don't know how we're going to do that either, but I do know this. If you have multiple barriers to getting a visa, you have to remove them all. And I learned this under like the Trump era of multiple proclamations. There was a time where I had Iranian clients who were being prevented from entering the U.S. by like 7 different barriers. They had a border barrier. They had this proclamation, that proclamation. Turkey had a problem, and so we had to remove them one at a time. And then once we peel away the layers, we're done. What I see some objections to the litigation that we're planning now, because especially with like the Iraqi, Afghan, and Sudanese clients that say, well, it won't guarantee me a transfer. And it's like, it probably won't, but it could. But here's the other thing. You have to remove all your barriers, not just the one that you see in front of you.
Agree. Yeah. And you're picking the biggest, most important target, and the earlier that's removed, the better for everyone, frankly. The earlier it's removed. But to the point that you're just alluding to, there's going to be other barriers for people.
Yeah,
right?
and I think that we're going to have other lawsuits, and we've definitely got other targets for the lawsuit. This policy, and you and I have argued about this before, because it's what they're doing actually, like, it's against the rules. So of course, like, it doesn't make sense. But like, if they lock somebody in and says, okay, you're DQ, they won't let them transfer their application. They're ignoring so many Iraqis, just like they did last year and the year before that, who chose Baghdad at their embassy, and then they won't let them transfer. And it's
but you understand my explanation of the it's not. So my position is, it's not the fact that they're DQ'd. It's the fact that they're DQ'd and current and allocated to the embassy. At that point, they're in limbo. Have you heard me making that explanation?
I understand what you. Yeah, I understand. I understand now.
Yeah.
I don't know if I did before, but I understand now. But the thing is, that is something that is so vulnerable. It's like low hanging fruit for a lawsuit. So I would like to do that lawsuit as the next lawsuit, but I don't know if that's going to work out, just because it's so unfair to. I mean, if people that live in Iraq and Afghanistan, especially, have gone through so much.
I know. It's
and
terrible.
What
or
people
Yemen.
in Japan are going through right now.
Yeah.
The idea that they don't have a U.S. embassy just makes it like one more layer.
No,
so
Cuba, Moscow, there's so many places that are being treated unfairly. No, it sucks. I mean, the political situation globally is terrible right now. But okay, so this lawsuit will attack the biggest, most immediate barrier, but you're not ruling out that somebody might then need to be in another lawsuit, possibly with yourself, and that might be another paid-for lawsuit, right, Curtis? That you don't seem to be ruling that out.
No, I think that that's probable that there's going to be multiple lawsuits.
Okay, so I think people need to be clear about that.
2021, we filed 3 big lawsuits in 2020.
So okay. So the bit I'm trying to make sure that and I understand your strategy could change, but the bit I want to make clear to people is that they could pay for this lawsuit, and then they might still have to pay for another lawsuit with you. And I'm sure by then they would trust you. They would,
or maybe somebody else. I'm not
somebody else, right? But they might need another lawsuit.
Not to file lawsuits.
Right. I get you. Yeah.
I want more people like the State Department.
Right. I did contact Jesse Bless about this. I had a couple of emails with him. Not today, a couple of months ago, saying, Jesse, is there any way that Ayla can fight this tiered 4 thing? But I think again, people are assuming that Ayla will come along and rescue everyone. The reality is, when they did the DV-2020 case, I think it was they had Justice Action Law Center, they had Innovation Law Lab, and they had a lot of support, I think, from Mayor Brown, because Mayor Brown were interested in the H1s, right? And so I don't think Ayla are equipped, frankly. I'm not knocking Jesse Bless or his team, but I don't think they have the resources, frankly, to handle a class action lawsuit on a pro bono basis. I don't see them coming in and being the white knight here, and I don't mean to offend anyone, but I don't think that's going to happen. I just,
Well, they're spread thin. There's a lot of immigration things.
They're fighting a lot of battles, exactly. How are they going to have the resources for this? So I know they've got concerns about these constant battles, but this is the position we're in. It's not your fault. It's not Charles Cook's fault. It's not Jesse Bless' fault. The bloody government could have reacted differently after they'd lost some of these battles in DV-2020 or DV-2021, but they haven't. They've continued. All right. Anyway, that's just me rambling.
No, we're on the same page.
Yeah. Okay. All right. I think I've clarified what I wanted to clarify, Curtis. I wanted to address that thing about, I've not been paid. I wanted to address that thing about lawsuits actually work. And I wanted to clarify the terms and the sort of the laser focus of your strategy right now being on tier 4 and what that potentially means. I feel like I understand those things, and hopefully the people watching the video will understand that a little bit better. Is there anything else you wanted to sort of clarify or clear up?
For the people that cannot afford to join this lawsuit, I just want you to know that it weighs on me heavily that I can't offer deferred payments on this one, and that hopefully we'll be able to catch you on the next one, or the one after that, or something like that.
Yeah.
Because I think it's really, really unfair what the U.S. is doing, where they tell people they won a lottery, and it's like, ha ha ha, like it's not really, you haven't really won anything. And so I don't think fairly, and I wish that you didn't even have to deal with the lawsuit thing.
Right. Yeah, that's an important point you're making there. I think it is a shame, and it's impossible not to be emotionally connected to once you understand the plight that people are going through. And for whatever reason, it doesn't matter whether they're coming from a first world country or a third world country or a politically stable country or a politically unstable country, whether they're wealthy or poor, it doesn't make any difference. Everybody has a dream, and they told you've won a green card, so they think. Right. It doesn't mean that. The letter doesn't mean that necessarily, but that's obviously what you think. It's what I thought. When my wife and my wife was a selectee in 2013, and it's what I assumed. I was like, the day we checked, I went home and I'm starting to sort of say, look, I've got to resign my job tomorrow. And obviously it was another year before, a year and a half or so before we actually got the green card. But you just assume that everything's ready, everything's great until you start finding out all the, but you got to wait for your case number, and there might be too many people selected, and all the risks, horrible. And then COVID happened, right?
Yeah.
Oh well, all right, Curtis. Well, look, it's fairly late. I'm on the West Coast here. I appreciate, very grateful that you took the time to be able to answer these questions, and also, you knew I was not going to be beating around the bush. I want to drive to the truth. I want to drive to the reality, and I'm always going to give you the blunt opinion of what I think. I'm going to give anybody that.
Yeah, and I like that. And I especially like it when you disagree with me, because it makes people think for themselves and consider like two different directions.
Yeah, exactly. So, I could be wrong. You could be wrong either way. But I agree with you. The good argument is actually is a very healthy thing. Good debate, good argument. Smart minds butting off each other. Hopefully, it's helped in some areas over the years, or over the last couple of years. I hope so. So yeah, I agree with you. I don't mind our arguments at all, although sometimes I can punch your lights out because you're an arguer for a living, right? I don't argue for a living. I solve problems for a living. But you argue for a living, and you would argue about anything, Curtis. You shock me sometimes.
Sorry about that.
Yeah. Anyway, all right, Curtis. Well, one day when I'm down in Southern California, I go down to Manhattan Beach quite a lot these days.
Oh, really? Okay.
So I'll have to touch base with you sometime when I get down there next. It's been lovely to talk to you.
Absolutely. Have a good night.
All right. Cheers, Curtis. Good night. Bye-bye.